Yeah, so we're down to 1, 2, 6. Okay. All right. Again, if you look at the total points, we said that if you get 90% at the end, if you have a 180 out of 200, you're going to get at least an A minus, and if you get 80%, you're going to get at least a B minus. So you got half your grade in right now, and again, the other half is going to be on the your paper, which is worth 20 points, and then the final worth 80 points. So, and the final is going to cover a chunk of what we covered so far because it's, cumulative. And so if you've done reasonably well on the first two exams, you should do pretty well on the final. And if you haven't done reasonably well on the first 2 exams, then you get another shot at it on the final. So let's just go over the exam today. If we look at the first multiple choice question, in joint and severable liability with contribution, right? It is not true that the victim can only choose to sue one of the parties, right? You can sue any of the parties in joint and severable liability. But the idea is with contribution, right? That is, you can't get 100% from everybody. You can't get more than 100%. I mean, if you could, then of course you could set up a situation where the victim would be better off being injured if they could get 100% from compensation from 5 different people. So that's why with contribution is in there to limit what you can get. So if you get 80% from one party and then you sue the second party, you could only get 20% from that second party. And then again, you can't receive perfect compensation from each of the injurers under with contribution. So the correct answer there is B. All those are true for number 2. When you're looking at efficient precaution, what are you trying to do? Like anything else, you're trying to get where the marginal benefit is equal to the marginal cost. And we said that with you, when you're looking at accidents, when you're looking at tort law, we assume just for the simple model that when X is the amount of precaution, that it goes up by an amount $, a dollar amount W. If you take an extra hour to get there by driving more slowly, that's a constant cost. And then on the other side, what do you get? You can reduce the expected value of the loss, and we just assumed the loss was A. And so what are you trying to do? If you're trying to minimize that, we said take calculus. What do? You take the first derivative, set it equal to 0, and so what do you end up with? You end up with W is equal to P prime of X times A. So the idea is if you spend another $1 in slowing yourself down or another $1 in precaution, let's say you build something into your product that you're making, and that's got to equal that to the reduction in the expected loss, right? And so P prime is the first derivative. How much are you changing that expected value times the amount that you have? So all those are true. Efficient precaution is where the marginal cost of increasing precaution equals the marginal benefit of increasing precaution that comes from reducing the expected loss. Turned out that all those negligence rules lead to give both the injurer and the victim incentives for efficient precaution. If you have perfect compensation and the legal standard is set at the efficient precaution, if you sort of know what that is. C, an argument for no liability or strict liability is they reduce the administrative costs of tort law, right? I don't have to prove that you were negligent, right? I mean, so it reduces the administrative cost to just say, strict liability, no matter what. I don't have to prove that you were negligent. So all the above are true on that one. Number 3, in order to receive damages under tort, which is necessary for the injured party to show? Well, you have to show the plaintiff has suffered harm, but you don't show the plaintiff performed a dangerous act, right? I mean, you have to have suffered harm for tort, right? You can't just say, oh my gosh, I was scared, I'm going to sue you over that. And you don't have to prove that the defendant intended to harm the plaintiff, right? I mean, that's what happens under criminal law. So the correct answer is not all the above, so the correct answer there is A. In order to recover damages under tort, you have to show that the plaintiff has suffered harm. Which of the following is true of tort law? Well, all those things are true of tort law. If there are consistent errors in estimating the damage of harm under strict liability, the injurer's precaution moves in the same direction. That is, if what happens is if they consistently underestimate the harm, then the expected loss to you is lower. And so what will happen is you'll take less precaution. And if they overestimate the harm, then the expected loss is greater. And so what are you going to do? You're going to take more precaution. So it's going to move in the same direction. If there are consistent errors in the court assessing who caused the harm, you get the same idea, right? That if oftentimes they get it wrong, so you actually caused the harm, but it turns out that they assume that you didn't, or the courts, on average say you didn't really do it when you did, what'll happen? You'll take less precaution. And if they overestimate, if you get convicted more often than you, or the court rules against you more often than you thought, than is the actual case, then what will happen is you'll go ahead and take more precaution. And then if it's random, then you wouldn't change the precaution, right? Because sometimes it'd be greater and sometimes it'd be less. And so if they're random errors, it shouldn't affect it. So all the above there are true. And then finally, which of the following can be a reason to hold the contract not to be enforced? Well, all those things. The court could say, well, there was a frustration of purpose, so there's really no reason to hold it. You agreed to, we did a contract to have a Broadway show, and then COVID comes along, and so it doesn't really, there's no purpose to doing it because nobody's going to show up anyway. Unconscionable, the court might say, well, you can't sell your child or something like that. And if it's necessity where they said, gee, I agreed to buy this gasoline from you at $500 a gallon because I'm out in the middle of nowhere and you'll refuse to sell it to me, or any sort of thing where it's like duress by saying you're not going to do it. That would be the necessity. So all those above are true. So any questions from you guys on the multiple choice ones? No? Okay. Number 1, true, false. If there is strict liability for product failure, the cost of production will include the expected accident cost. Well, that's true because if there's strict liability and I'm making the chainsaw or I'm making the ladder, I know that if something happens, I'm going to have to pay the cost of that. Well, I'm going to put the precaution into the cost of the chainsaw. I'm going to make it a little more safe with the chain, or make it a stronger steel with the chain, or I'm going to make the ladder so that it's not quite as flimsy. It's going to be really sturdy. And so when you go to buy the ladder or you go to buy the chainsaw, that cost of production, that extra cost of production that is embedded into the product because I'm making it safer is going to be in that marginal cost, and so price equals marginal cost, and so that'll be in the price. 2, the authors argue that in the case of universal insurance and competitive markets, insurance is like privatization of liability law, right? We talked about that. That if you have universal insurance and you have competitive markets, what will happen, like in in auto insurance, where you can buy insurance where if you're held liable, the insurance company is going to pay for it, et cetera. So what will happen is that the insurance companies will then meet in court, your insurance company against their insurance company. And so that's their argument, is that in certain instances, particularly with regard to auto insurance in particular, you can see that it sort of looks like a privatization of that legal structure. 3, the awarding of punitive damages creates more certainty in the expected cost of accidents. Well, it's just the opposite of that, right? If you don't know, if what can happen is the court can not only make you pay the expected loss, or pay the loss, perfectly compensate the victim, but they could throw some stuff on top of it. You don't really know what that might be, and so now I've introduced some uncertainty into what I might have to pay, and so that's going to be the opposite. So the awarding of punitive damage is going to create more. It's going to create less certainty, more uncertainty in the expected cost of accidents. Number 4 is true. If there's a mutual mistake about the object that was bargained over, an argument for restitution as a court-ordered settlement is that there was not truly a bargain, right? There wasn't truly a bargain because you thought you were buying this thing and I thought I was selling you this other thing, so it wasn't really a bargain. So the argument in restitution is you just give the money back. Right? You just return the parties to where they were when they started. And then finally, frustration of purpose means that the contract was signed under duress. Well, that's not true, right? Frustration of purpose means there's no reason to do it now. All right. Any questions on the true-false part? Okay. All right, and everybody did well on basically did well on the true, false, and the multiple choice. All right, what's meant by vicarious liability? Okay, well, if we're looking at vicarious liability, the broader way of expressing that is one party can be held liable for actions of the other party. Now, particular examples, I didn't take off. I mean, if you gave a particular example where you said it could be we gave examples of the owner of a franchise. The owner of the McDonald's Corporation could be held liable for the actions of a franchisee, or if you were an employer, you might be held liable for the actions of the employee. But generally, it is broader than that. That is, if you think about it, you might be held liable for the actions of your children, right? And so the idea here is that the person that has a broader knowledge of what the proper precaution is would be the one that would be held liable. And so I would be more careful about training my employees, and I have more knowledge about the safety use of the lawnmower or something that you're using or whatever. So I would have an incentive to take more precaution about who I was hiring, about telling people, training the people. I'd take more precaution about what my children were doing. So again, if we, those that had 105 and we were talking about Hayek's idea of responsibility in the Constitution of Liberty, the idea was, why do you want to have people responsible for their actions? It's because they will behave in a more efficient fashion, right? And again, Constitution of Liberty is worth reading anyway, if you haven't had 105. But it's a similar idea here, right? I'll make more efficient use of the information of the party that has the best option of being able to figure out what the most efficient amount of precaution is. So, and then provide an example. People were able to do that. So what's the brief argument in support of strict vicarious liability? Strict vicarious liability where you don't have to prove that. If you had just vicarious liability, you might set it up so that you had to show that the employer was negligent in supervising the employee. In strict vicarious liability, you don't have to do that. And one of the arguments, of course, that we just were talking about, that who has the best information about the amount of precaution that you ought to take would probably be the company. McDonald's would know more than an individual franchisee, so they would have the franchisee have to go to some sort of school or something, or take take some sort of training course or something like that. Similar with employees, and so that was the primary reason. You want to have the party that has the best information be the one that's making the decisions about what the proper precaution is. All right, any questions on that one? All right, number 2 was briefly discuss the economic incentives on parties to take precaution under no liability and strict liability, and then tell me what they are, right? So what we know about strict liability is that the injurer is liable, right? Has to compensate the victim. That's under strict liability. Now, again, we could think about what is the economic incentive. Under this, the potential injurer has the incentives that they're in, what, as the author sort of talk about, internalize the cost of the accident. And so, if the injurer is liability, then they will take efficient precaution, right? And in particular, right, they'll set, right, the marginal benefit, which is the reduction in the expected loss, equal to the marginal cost of the additional precaution. Because under strict liability, the injurer is going to have to pay all the costs to compensate the victim. Now, under no liability, right, you get just the opposite, right? Under no liability, what's going on is that the injurer, as you know, again, sure not like rocket science here, right? The injurer has no liability. So what happens is that the victim bears the cost of the accident. Well, you're going to get the same thing, right? You're going to get that the victim is going to take proper precaution or efficient precaution. Again, we're assuming that somehow everybody knows what the marginal cost of the precaution is, and we're assuming that that the victims are perfectly compensated. Somehow that could actually happen, right? But you assume that you have perfectly competitive markets in ECON 202, right? That I can sell one more unit at the market price, right? And that I don't produce enough to change the aggregate supply curve so that the price doesn't change. So, it's not unusual to make this kind of assumption here. So the victim's going to take efficient precaution. So now you deal with, okay, how does a negligence rule work, and how does it affect the total amount of, the incentives of both parties with regard to precaution? So let's take a look at the important point here is that there's a sudden drop in the expected cost when you hit the efficient point, right? I mean, the logic of this thing is that the way it works is under a negligence rule, there's strict liability if the injurer is negligent, right, that is, fails to take efficient precaution. Now again, we're sort of assuming that the courts sort of know, or the standard is out there. There's some law that says here's the amount of efficient precaution, okay? 55-mile-an-hour speed limit, or whatever. So somehow we know what the efficient amount of precaution is. So so we're assuming that either there's an industry standard or there's a law that defines what the efficient precaution is, so that I'm the injurer, I know what the efficient amount of precaution is that I got to meet. So if the injurer fails to take efficient precaution, what do you have? You have strict liability. Okay? And we know under strict liability, we just mentioned under strict liability, what happens is that the injurer, potential injurer, is going to take the efficient amount of precaution. And then what happens is there's no liability if the injurer meets the efficient precaution standard. So what this means is that there's all of a sudden drop in the expected loss that would have to be paid by the potential injurer, right? There's a sudden drop, and that drop would be significant, right? Because you're going from a strict liability where I got to pay I got to perfectly compensate the victim, to I don't have to compensate the victim at all. So it's not like it's a $15 difference, right? It's going to be a big difference at that one point. So there's a sudden drop and a significant drop in the expected cost to the injurer at, we'll call it X star, okay? Let's say the efficient amount of precaution, and we'll just to make it easier, X star. And so what will happen? We know that they will take X star precaution, right? So what happens? We know that the injurer will take X star precaution, right? What does that mean? It means there's now no liability. And then it's just a matter of logic, right? That is, the potential victim knows that the injurer is going to take efficient precaution, so there's a no liability standard now. So the victim knows there's a no liability standard. So what does that mean? Under no liability, we know that the victim is going to take efficient precaution. So the victim takes efficient precaution. So it's this flip from strict liability to no liability that occurs when you have taking the efficient precaution. Again, this is sort of assuming that we know, I mean, to have it perfectly work out, right? To have everybody taking the efficient amount of precaution, somehow we got to know what X star is for the potential injurer. But, you know, it gives you an idea that I'm going to get, if I have a guess, you know, maybe you shouldn't be doing 100 miles an hour in a school zone, okay? Maybe you shouldn't be turning left without signaling. Okay, So there's issues where we probably have a decent idea, just as like when we were talking about property law, we might have an idea about, okay, if there's transactions cost, whoever I assign the property right to is going to keep it. There might be some things that we say, yeah, we can pretty well guess what it's going to be. So at least it gives you a mechanism whereby, okay, negligence is going to have a better shot at both parties taking efficient precaution than under either party. Again, the same thing that we were talking about in strict vicarious liability. There are administrative costs in trying to figure out what the efficient amount of precaution is, proving that you were negligent when you were driving or whatever. There may be cases where it's easy to do that. Maybe they have things where they take pictures of your car when you drive through a school zone or something like that. But again, it's just a matter of giving you guidance on what the amount of law ought to be, or what the law ought to look like. So, any questions on that one? Right. I would say, in answering the exams, this logical part of the argument was the weakest part in people's responses. That is, they were not clear in showing that, okay, here's how it works. Strict liability, if you fail to meet the standard, no liability if you meet the standard. And therefore, there's a sudden drop in the expected cost to the injurer if they hit the efficient precaution. So they're going to do that. The victim knows this is the optimal spot for the potential injurer, so they know it's likely that there's going to be a no liability situation, and so they will take efficient precaution. All right, number 3. When is a breach of contract efficient? Okay, well, a breach of contract is going to be efficient when what? When the cost of fulfillment, so we got a breach is efficient, right? When the cost of fulfilling the contract is greater than the expected benefit. All right? And that makes sense in that why would I go ahead and fulfill the contract when there's something's happened and makes it so that it's now significantly more expensive, so that because we wouldn't have signed the contract if the cost of fulfillment was greater than the expected value of the contract. We wouldn't have got into the contract. We wouldn't have bargained that way. So it must be that something happens to alter the situation so that there's an increase in the cost of fulfillment sufficiently large that it makes it so that the cost of fulfillment is greater, or fulfilling the purpose, or excuse me, fulfilling the promise is greater than the benefit to the party that was receiving it. So then it says, briefly explain why in the case of unfortunate contingency, the remedy of damages will generally be more efficient than the remedy of specific performance. Okay? Some people said that unfortunate contingency makes it so that the cost is greater than the benefit. But an unfortunate contingency could come along and it raises the cost beyond what I was thinking when I was the promisor, but it doesn't make it large enough that the cost is now greater. Okay? So an unfortunate contingency just means that something happened that raised the cost of performing. It could be that it raised it enough to create a situation where the cost of fulfilling the contract's greater than the benefit, but it might not have raised it that much, okay? So I just want to, make sure that you're clear that we have a particular case of unfortunate contingency where it raises the cost sufficiently that it makes the, makes the cost of fulfillment greater. So why would that be more efficient than specific performance? Well, it's because the same reason that we talked about for trespass. That is, I could have a forced sale, right? That is, under trespass, what I could do is I could choose to trespass and then compensate you, right? And so if the benefit to me of trespassing was greater than the cost to you of my trespassing, I'm going to give you perfect compensation, and then we're better off, okay? So it's a very similar idea here. That is, if you have damages, then what happens is whoever's going to be the party that's going to breach the contract, right? We'll just let's assume that the promisor is going to be the one that breaches the contract here. But whichever party breaches the contract, okay, the promisor can choose, right, to breach and pay the damages. And what are the damages? They're the expected benefit, right? They're going to pay the damages, which is the expected benefit. So if there's an unfortunate contingency, they can do that. So if the cost of performance or fulfillment, right, the cost of performance is greater than the benefit, what will happen? They'll breach, and that's going to be efficient, right? If the cost of performance is still less than the benefit, they'll go ahead and fulfill the contract, right? They're not going to pay damages greater than the cost of performing. Now, if the cost of performing is less than the benefit, what will happen? They will perform, right? So the specific performance, they will choose to do that if the unfortunate contingency has not raised the cost greater than the amount of the expected benefit from performing. So this has got to be efficient, right? If under damages, whoever was going to violate the contract can say, you know what, the cost of performing this thing is greater than the benefit. I'll choose to breach and I'll pay. If the cost is not greater, so it's inefficient to breach, then what will happen is I will perform. So that's going to be correct. Now, if you choose specific performance, it might be efficient. Okay? If what happens is the court says, okay, specific performance, you have to do it, and it turns out that if the cost is less than the benefit, then it's going to be efficient. But it's possible that the cost is greater than the benefit. Okay, we require specific performance, and it's inefficient. So sometimes you'll get it right, and sometimes you won't. So it's not as if specific performance will always get it wrong, right? Sometimes it could get it right, but sometimes it can get it wrong. Whereas damages, you're always going to get it. You're always going to get it right. Again, you might want to take a look at in the book. I'm I'm wondering how many people are actually reading the book, but if you on page 326, there's that discussion. If you want to just take a look at the textbook, it begins on page 326 and goes through. Now you could have talked about if there's low transactions costs, it doesn't matter how you do it. Now, notice that, again, excuse me, this is like this is like when we were assigning the property right? Sometimes you'll get it right? Under the Coase theorem, it would say that it doesn't matter who you assign the property right to because the parties will bargain and it will go to the person that values it the most, So, I mean, it's not exactly the same, but you can see there's similar thought processes going on here. That under the property law, we said that if there's high transactions costs, then you got to get it right? You got to get it to the person that values it the most. If there's low transactions costs, it doesn't matter. And what you've got here in a breach of contract is that you have, as we said before, a forced sale, just as with trespass was a forced sale, and you can allow that, but if you do that, then you got to get the compensation correct. So, all right. Any questions on the efficient breach? All right. So, sort of summarize on that one is damages give the person that's going to breach, it gives them the ability to choose whichever is less expensive, whereas specific performance, you don't. Now, some people pointed out that, just as with anything else, how do I know what the expected value is, How do I know what the expected return really is? So again, it's giving you direction and specific performance. Some people talked about what if you have a unique product or whatever. But if you have I still got to figure out, if I was to do it right, I'd have to figure out what that value of that unique product is to know whether it was better to do the specific performance. Now, again, from an administrative costs, it's easier to do specific performance. The administrative process, hey, I don't have to figure out what damages are. I'm just going to go ahead and say, hey, you got to perform. That's obviously the cheapest thing to do from an administrative point of view. But from an overall efficiency, a market efficiency point of view, then damages are going to be the thing that gives you the most efficient outcome. All right. Next one is, what is the paradox of compensation? And this has to do with contract law. And the paradox is, the real paradox is you can't get the same thing that you do in tort law. You can't really get a situation where both parties result in efficient precaution. That's the paradox here. So what is the paradox of compensation? It just says that if you have perfect expectation damages, then what's going to happen is that the promisor will take efficient precaution. They can do things to prevent a breach, They're going to take efficient precautions to go, okay, hey, maybe I should make sure that we've got a backup plan of some kind, We're going to have a alternative way of getting there, or we're going to take out an insurance policy. We're going to do something to have a backup plan in order to make it so that it's less likely there's going to be a breach. Now, That's the equivalent of strict liability, right? I mean, that's the equivalent of strict liability under tort law. But what's the problem? The problem is that the promisee, what will they have the incentive to do? They have an incentive to over-rely, right? They're going to rent a bigger venue than they otherwise would, right? Or they're going to, they're going to buy more food because they know they're going to be compensated. And if they bought more food, they would have a higher, more folks they're going to sell to. So the expected benefit of the contract is going to be greater. So why do I spend money on doing things that will increase that will be related to the contract itself? I'm going to spend money in order to improve the expected value, right? So if I have if I'm going to rent a venue with only 100 seats in it, I can only sell 100 tickets, right? Whereas if I rent a venue with 500 seats, then I can have a higher expected benefit. So if I know that if I'm going to be compensated if you fail to bring your band to the show or something, if I know I'm going to be compensated for the 500-seat stadium or venue rather than the 100-seat venue, I'm going to go ahead and rent the 100-seat venue. And so there's an incentive to overlie. So the more that you pay in compensation, there's more incentive to take less precaution by the promisee. Right? They go ahead and order food for 500 people rather than saying, well, we better be a little bit careful. Maybe I'll just order food for 400 people, and I'll only try to sell 400 tickets to the basketball raffle. We used to have. Anybody ever been to one of those? Go to the basketball raffle. Used to always buy tickets for that as well. With actually Bruce Lykow. Some of you had Bruce Lykow, maybe. He's been retired for a while, so I don't know if any of you have had Bruce Lykow, but he used to. We used to get together and buy tickets for that. But anyway, but so that's the point. Now, what is the paradox? Is that it's not possible in contract law for both parties to take efficient precaution. Whereas the negligence rule in tort law the negligence rule allowed you to do that. The authors talk a little bit about hypothetical compensation, but argue that that's really not possible to do. Again, if you look on page 333 of the text, that's where the further discussion of that. So, any questions on that one? All right, let's look at the last question. Briefly discuss the difference between expectation damages, reliance damages, and opportunity cost damages. Okay, so we've already sort of gone over much of this. What is expectation damages? Expectation damages is that you're awarded what the promisee expected to benefit. Right? That's what's called expectation damages, right? You're going to say, okay, I expected to make $500,000 on this program where we've got Paul McCartney coming in or something like that. And so that's what I'm going to get rewarded. Now, what's an example of, I just said, unfortunately, some people just forgot to put examples in. And so that was a little bit costly. I took off, I was giving like 1 point for an example. So if you forgot to do any of the examples, then unfortunately you only had 7 out of 10 to start with. But an expectation damages would be where you're going to basically put the person in the situation that if the contract had been fulfilled. So again, I'm supposed to give a lecture, and you were going to sell tickets to my lecture, and so you rented this venue, and you expected to get $500. Or let's say that's really expensive. Let's say you're expecting to get like $50 per person, right? Then and that was after. So you'd have to look at what. You'd have to subtract off what you paid me, right? It's the benefit to you, the net benefit to you. Not you'd have to say, you have to subtract off the cost. So if the contract had been fulfilled, here's what I would have gained, right? So then what would happen is I would have to pay you what the profit that you would have had I shown up. Okay. Opportunity cost is second best offer, right? Whatever you could have had had you turned down the ability, or this is an opportunity cost. You could have done this other thing, but you didn't. So I would have to pay you for that. So you could have, let's say, you could have, instead of doing Paul McCartney, you could have done Justin Bieber, and so they would have to pay you what the profit you would have gotten, what was the benefit from the Justin Bieber concert, would be what what Paul McCartney would have to pay if Paul didn't show up. And then, of course, reliance damages are the expenditures that you made in anticipation of the thing happening. So, let's say you took an airplane, I'm going to give my talk, and I fly out to Tucson, and I rent a car, and I get to the venue, and, then it's been canceled, okay? They would have to pay me for the costs that I incurred in attempting to have the contract fulfilled. Okay. Now, there was a few people that got reliance damages and restitution damages mixed up. They gave examples where that we talked about earlier. You think you're buying this product from me, and I'm thinking that I'm selling a different product to you. Then I just have to, you just have to give me my money back. Okay, that's restitution. So don't confuse restitution and reliance. Reliance is what you spent in anticipation of the contract being fulfilled. Okay. All right. Any questions on that? All right. I tried to write notes I wrote comments on everybody's exam. I haven't quite thought through how I'm going to get those to the people that did not take the exam in class. So we'll deal with that. But so we'll continue with criminal law on Monday. So you might eventually what we're going to do is we're going to do the 2 chapters on criminal law, and then whatever time we have left, we'll look at the legal institutions. All right.